I have trouble with that one. It wasn't.
What? Who? Jaime Mario. Right here. Yeah, see. No, Fine. What? Okay, well, sure. Or just really.
All right, Mr. Manning, who are you ready on?
Judge, if you'd like me to do the pleas first, or we need resets, whatever you prefer.
You tell me.
Okay, let's start with Mr. Douglas Paniagua.
Mr. Paniagua, if you'll step up, please. All right, this is cause number CR 22-245, State of Texas versus Douglas, Adrian Paniagua. Mr. Paniagua, if you'll raise your right hand, sir, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your. All right, give me a moment here. Let me pull up your. Pull up the motion. All right, Mr. Paniagua, I'm showing you The state's motion to adjudicate in this cause indicates that you were before the court on November 29th of 2022. You pled guilty to the first-degree felony offense of manufacture or delivery of a controlled substance, penalty group 1 between 4 grams and 2 grams. Court heard the evidence on that day, found that there wasn't enough evidence to convict you. The court deferred a finding of guilt, followed a plea agreement on that day, placed you on 10 years of community supervision, and ordered you to pay a $2,500 fine. It was during this period of community supervision that the state of Texas filed its motion to adjudicate on what appears to be September 28th of this year. And in this motion, they have alleged what appears to be 9 separate counts of various violations. Have you had enough time to review this with your attorney, Mr. Manning?
Yes.
And do you, you feel like you've had enough time to talk with him about this motion, prepare a defense, and you have had answers to all of your legal questions?
Yes.
Is there anything about the paperwork that you've read over and signed today as part of your plea agreement that you do not understand?
No.
Mr. Manning, do you believe your client to be competent today?
Yes, Judge.
Have you explained to him his rights as they pertain to this motion?
I have.
Do you believe that he's entering into this plea agreement with the state intentionally, knowingly, and voluntarily?
I do.
All right. And does your client intend to plead true to all 9 counts?
Judge, he is going to plead true to all 9 counts. We'd just like to explain on the sanctioned court violation, I believe that's violation U, that he was actually in custody in Kaufman County on a Class C ticket. He did not intentionally miss sanctions court, and he wanted the court to know there was no disrespect in that, but he was in Kaufman County on a Class C ticket at that time.
Okay, appreciate that. Okay, then Mr. Paniagua. And Mr. Manning, does your client waive the formal reading of the state's motion to adjudicate?
Yes.
All right, Mr. Paniagua, then I would ask you at this time, how do you plead to counts 1 through 9 as contained in the state's motion to adjudicate? Are those counts true or not true?
True. And Judge, if I may, my client was just pointing out, I don't know if it makes any difference, but his name is spelled correctly in the judgment. However, he noted that it is not spelled correctly on the motion to adjudicate. It looks like on the motion to adjudicate that was filed September 20th.
It's missing a U.
That's correct, Judge.
Okay, all right, Mr. Hartwell, can you, on the judgment there, Mr. Manning, is it spelled correctly on the judgment?
It is, Judge.
Okay, all right, then the motion shouldn't have an effect as much as the judgment. So as long as the judgment adjudicating guilt appears to be correct, we shouldn't have any issues. Okay, and Mr. Paniagua, you're telling me that all 9 counts are true because of the fact they are true. You're not just saying that to get a plea agreement. Is that correct?
Yes, sir.
All right, Mr. Paniagua, has anyone threatened, forced, or pressured you to plead true to any of these counts in court here today?
No, sir.
All right, the court will accept the defendant's pleas of true to all 9 counts. Mr. Manning, any objection to the admission of the defendant's waiver of rights of plea of true?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confessions. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Press and close, Judge.
All right, then based on the evidence before the court finds that Mr. Paniagua has violated the terms and conditions of his community supervision. Court, the state will follow the plea agreement reached between the defense and the state. The court hereby adjudicates the guilt of Mr. Paniagua, convicts him of the first-degree felony offense of manufacture or delivery of a controlled substance, penalty group 1. Court assesses will revoke community supervision, assesses punishment at 8 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations. Court does dismiss under section 1245. DA, calls on DA 2022-1108. In addition, court orders Mr. Paniagua to pay the balance of his financial obligations, including fines, court costs, and reimbursement fees. And the court will award Mr. Paniagua 94 days towards his sentence for time for credit time already served in this.
Judge, and If I may, there was a correction on that. The actual time served was 150 days. I pointed that out to the DA's office. They provided me a corrected copy, and that copy that my client has signed does have the correct 150 days.
150.
That is correct, Judge.
No, my judgment was not. All right, then the court will award Mr. Paniagua all time that he has spent in jail on this case prior to today, reflected as 150 days. Mr. Paniagua, once you do serve your time in TDC, once you're released, if you have not already taken care of your fines and court costs, fees, you'll need to report to the Van Zandt County Courthouse upon release and make arrangements to discharge those either in full or with a payment plan. Okay.
Yes, sir.
All right, Mr. Paniagua, you hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Good luck to you. Please step over with a deputy to be fingerprinted.
Thank you.
You're welcome. Who's next, Mr. Miller?
There's next we have Mr. Ronnie Dwayne Cotton.
All right, Mr. Cotton, this is cause number CR 22-240. If you'll raise your right hand, I'm going to place you on oath. Mr. Cotton, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Your name is Ronnie Dwayne Cotton, correct?
Correct.
And Mr. Cotton, are you a United States citizen who reads, writes, and speaks English?
Yes, I am.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes.
Do you understand everything that you've read and signed as part of your plea agreement?
Yes.
And you don't have any questions about anything before we proceed, is that correct?
No, I don't, Your Honor.
Mr. Manning, do you believe Mr. Cotton to be competent today?
He is, Judge.
Have you explained to him his rights as they pertain to this case?
I have.
And do you believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
I do, Judge. We've had multiple opportunities, both when he was on the outside and while he was in jail, to discuss the facts and potential defenses to his cases. He has entered into this plea intentionally, knowingly, and voluntarily.
Thank you. I see that Mr. Cotton is indicted with a third-degree felony offense of possession of a controlled substance, penalty group 1 between 1 gram to 4 grams. That does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and a fine, if imposed, not to exceed $10,000. I see the plea agreement with the state is that Mr. Cotton would plead guilty. His punishment would be assessed at 10 years confinement in the Texas Department of Criminal Justice. He would pay restitution of $180, court costs of $290, and reimbursement fees of $175. And as part of the agreement, the state has agreed to abandon its enhancement paragraphs. And then Mr. Cotton would receive credit towards the sentence for time that he's already spent in jail of 256 days. Is that your understanding, Mr. Manning?
It is, Judge.
Is that your understanding, Mr. Cotton?
It is.
All right, then, Mr. Cotton, how do you plead to possession of a controlled substance in penalty group 1 between 1 gram to 4 grams, a third degree?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Correct.
All right, the court accepts Mr. Cotton's plea of guilt. Mr. Manning, any objection to the stipulation of evidence supporting this plea?
No objection.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Nothing from defense, rest and close.
All right, Mr. Manning, the stipulation was not provided to the court. Can you recite on the record the stipulation of evidence?
Yes, on or about March 14th, 2021, in Van Zandt County, I, Ronnie Cotton, was at the Washateria in Grand Saline where law enforcement was called out for disturbance. It was found that I had a warrant. After being detained on the warrant, officers got a warrant to search my vehicle where they found that I had what DPS lab confirmed to be 3.09 grams of methamphetamine.
Thank you, Mr. Manning. All right, and based on the evidence contained in the stipulation, the court finds that there is enough evidence to convict Mr. Cotton of this offense. We'll follow the plea agreement. Court hereby convicts Mr. Cotton of the third-degree felony offense of possession of controlled substance, assesses his punishment pursuant to the plea agreement of 10 years confinement, Texas Department of Criminal Justice, orders him to pay restitution of $180, court costs of $290, reimbursement fees of $175, and awards him 256 days credit towards the sentence for the time that he's already spent in jail on this matter. Court also finds the enhancement paragraphs to be abandoned by the state in both paragraph 1 and 2. Mr. Cotton, you're hereby remanded to the custody of the sheriffs to carry out the terms and conditions of the sentence. Please step over with the deputy.
Thank you, Your Honor.
You're welcome, sir. All right, who's next, Mr. Mayor?
Next, we have Mr. Eric Sperling.
All right. This is cause number CR 22-157, State of Texas versus Eric Sperling. And I understand there's an agreement. Go ahead. What is that agreement?
Judge, the state has agreed to withdraw, motion to revoke, and continue him on probation with the following amendments. Condition M1, that he pay the balance of financial obligations that have been updated, the court cost, fine, attorney's fees, a total of $3,395, and that will be assessed as a condition of his probation. Additionally, that he be sentenced to a term of confinement not less than 6 months, more than a year in safe P, and that he do ISP upon completing the safe P portion of his probation. Additionally, condition Y, that he should attend weekly counseling. Condition Z, that he submits to a polygraph to the
Jill here. Mr. Manning, can you hear us?
I can still hear you, Your Honor.
Looks like we lost contact with Jill there. Let's see if they can come back in. Jill's having to restart their system. We'll just stand in recess and wait for them to rejoin.
Yes, sir.
You hear us, Judge?
Yes, I can hear you. Okay.
Okay.
Excellent. All right. So Mr. Manning, where I lost you, you had, I think you got down, my last recollection was maybe condition M. I think you said that there was going to be a modification to those things, but my understanding is that there's going to be continuation with safety and ISP after that. And I think you said maybe condition M or something.
Yes, Judge, condition name is the financial obligations have been modified to include representation in this case and to include his time payment for when his time gets out of safety.
Okay. And is probation supportive of this for Mr. Sperling? They believe that he's a good candidate.
Judge, I spoke to his officer Dan, and he was willing to get behind this. Unfortunately, he didn't get much time with Mr. Sperling as you can see on the violation report. There were positive tests pretty soon after he was put on probation. So Mr. Gann believed, I'm not going to put words in his mouth, but I think Mr. Gann agreed that giving him a chance to conquer his addiction and maybe have a fair shot at probation was the best course of action for this case.
Okay. Eric, I want to ask you a couple of questions before we go any further, okay?
Yes, sir.
So I don't mind sending you down to safety. I don't mind giving you a chance at rehab. I just need to make sure that you're wanting to go and that if you go down there that you're going to take advantage of what they're going to tell you and what they're going to try to educate you on. Some people see safety as the quickest way to get back out and free, and they don't take advantage of what rehabilitation really is, and that's education. That's changing the way you think, changing the way you act, changing behavior modification, those things. So it's a process, and it takes a lot of work to go down there and actually work on yourself and change things about yourself. And so only the person that's going to be successful with that is a person who's willing to do that. You're telling me today that that's what you're willing to do and want to do.
Yes, sir.
Okay. All right. So go ahead and raise your right hand. I'm going to place your oath. Mr. Sperling, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. All right, Mr. Sperling, has anybody threatened, forced, or pressured you to make an agreement with the state today to modify your community supervision to place you in the substance abuse felony punishment facility and amend those conditions that Mr. Manning read into the record earlier? Has nobody's pressured you to do that? You're doing that because that's what you want to do, and that's how you think it's best to resolve your case.
Yes, sir.
Okay. All right, then the court will grant the state's motion to withdraw the motion to revoke. The court will continue Mr. Sperling on community supervision. The court will modify his conditions of community supervision to include placement into the safety program, and also the any resulting placement on intensive supervision and any other conditions that are implicit with attending the safety program, and what will modify the other financial obligations as reflected in the agreement. So Eric, it might be a week or two before they come and pick you up and they have a bed available for you. So I know that this is a difficult time to be going. So hope that you go down there and you get the help that you need. You come back and do what Mr. Manning says, have a fair shot at probation, be able to live your life on the outside.
Thank you, Judge.
You're welcome. Good luck to you, sir.
Thank you.
Your Honor, when you say the Spanish interpreter, would you let us know?
I sure will, and look right now.
Thank you.
Okay, so I see you waiting in the district court witness, right? So that's just your interpreter. So I'll hold that out. As soon as I see them, I'll let you know. And they're not scheduled till 2:30, right?
Well, Mr. Manning had me call to see if they could appear earlier. And so she said she would get on as soon as she finished with the 1:30.
Okay. Well,
Also, Corey Butler is here.
okay, where we thought he was in federal custody, he's actually here. Oh, lost him again. Well, we're not having luck today, my friend.
Well, of course not, Your Honor. It's only 11 folks, so it would be a little bit of a rougher day.
Yeah, of course, of course. All right, let me tell him. It's happening. Next year must be bad, so. All right, let's see if they can get logged back in. We'll just stay in the recess and wait for them.
Okay, we don't know what our issue is out here.
That's okay.
Okay. Mr. Butler says that he has hired Mr. Millslagle. So not Mr. Trainer.
When did that happen?
3 months ago? 3 months ago.
Okay, so there's no way for us to have known that, so. Without him telling us, or Mark Trainer, or Mr. Millslagle. Did Mr. Millslagle file a notice of appearance or letter of representation, do you know?
Not to my knowledge.
Seems like that's attorney 101 when you get hired by an individual.
Judge, I'm in the case, and the last thing that's filed as a representation is Mark Trainer.
Okay, and I guess Mr. Trainer, is he not appearing today? Ms. Digger?
I tried to reach Mr. Trainer, but I haven't gotten a hold of him.
Okay, when
I had
that,
sent him an email the week before, the earlier part of the week, to see if Mr. Butler was still in federal custody, and I did not get a response.
okay, well, I need Mr. Trainer and I need Mr. Millslagle. So let's, Wayne, if you'll try to call Mark Trainer, and then what's Mr. Millslagle's first name so we can look him up?
Matt.
All right, we'll try Mr. Millslagle as well, and hopefully we'll get somebody on here for Mr. Butler. All right. And Mr. Manning, don't stand real still. If you stand real still, I'm gonna think you froze up.
Judge ready on Mr. Brittain?
All right, Mr. Brittain, come on down.
Judge, we have received a copy of the indictment. I've gone over that with my client. His name is spelled correctly. He understands the charge against him, and at this time pleads not guilty. Request to be set on the pretrial docket. Additionally, Judge, we have received offers in his case. I've discussed those with Mr. Brittain today, and we are looking at getting this case resolved sooner rather than later.
All right, this is cause number CR 23-204, State versus Jimmy Don Brittain. Mr. Brittain, having waived the formal requirements of arraignment, the court will enter his plea of not guilty into the record. Finds that he understands what he's charged with and the range of punishment. He is represented by counsel. Court sets him for pretrial on February 1st at 1:30. If he makes bail, of course, his hearing would be at 9 a.m. on that same day. Austin's, yeah. All right, let me call out this. Stand by. As soon as they log back in. I do have Mr. Trainer in the waiting room, so as soon as we can get going, Patty said she's gonna try to get the laptop up and going with a hotspot. I'm being told that their phone system keeps going down out of the sheriff's office and all that's connected to it too.
Oh, okay, that makes sense.
So she's gonna try to get a laptop up and hotspot going, so let's give her a second.
Sounds good. Thank you, sir.
Okay, talk fast.
Yeah,
So I talk fast and my court reporter is gonna shoot me. Are you getting the laptop up and going too though, Patty?
We're trying, but it's not connecting it.
All right. All right, Mr. Manning, I believe that I completed the hearing on Mr. Brittain. I indicated that I understood that he was waiving formal requirements of arraignment. I entered his plea of not guilty into the record. I set him for pretrial on February 1st at 1:30.
Yes, Judge, and our final request on him was just that if we do reach a deal before then, if we could have the indulgence of the court to appear before then.
Absolutely, for sure.
Thank you, Judge. Next, we have Mr. Michael Davis.
All right, Michael Edward Davis, CR 22-176, CR 22-124, CR 23-125, CR 23-149. Sure, there
Judge,
was a docket call on a couple and pretrial for the last two.
yes, Judge, if we may, if we just move all those cases to docket call, I do have a couple more things to go over with my client on the new cases. But we are at this point continuing negotiations as we move towards docket call.
All right, court will find that there are no contested pretrial motions. Court sets all of Mr. Davis's cases on February 1st at 1:30 for docket call.
Thank you, Judge.
You're welcome.
Judge, next we'll have Mr. Gladney.
Mr. Gladney, CR 23-214. Is it pronounced Cravon?
Yes, sir.
Okay, Cravon Malik Gladney, set for arraignment. Go ahead, Mr.
Judge, Mr. Gladney's name is spelled correctly. He understands the charge against him as well as the range of punishment, pleads not guilty. We've discussed potential offers on his case as well as a bond reduction. But at this time, Mr. Gladney is going to remain in custody pending a resolution on this case. We request to be set on the pretrial docket for February 1st.
All right, the court finds that Mr. Gladney has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record, finds that he understands what he's charged with, the range of punishment. He is represented by counsel. Court sets the matter for pretrial hearing on February 1st.
And Your Honor, if I may, the indictment on that one, I believe, at the heading, it says that it's a felony third. However, the language in it actually alleges a second-degree felony.
Judge, I have spoken to my client about the various levels, ranges of punishment, and with that clarification, I will inform that it is 220.
Thank you, Mr. Manning. All right, who's next?
Next, we have Mr. Gilchrest.
CR 23-213, State versus Gordon Alexander Gilchrest for arraignment.
Judge, Mr. Gilchrest's name is spelled correctly. He understands the charge that's against him. Additionally, Judge, I've spoken to the DA's office and they believe there to be forthcoming charges. So at this time, we plead not guilty to this charge and request we set on pretrial pending the new information provided by the state.
All right, the court finds that Mr. Gilchrest has waived the formal requirements of arraignment. He understands what he's charged with and the range of punishment. He is represented by counsel. The court enters his plea of not guilty into the record and sets this matter for pretrial on February 1st at 1:30. About Mr. Glasgow.
Yes, Judge.
Mr. Glasgow, CR 23-215. Mr. Glasgow set for arraignment on burglary habitation.
Judge, at this time, I have not received a copy of the discovery. Additionally, Mr. Glasgow was not indicted within the 90 days, and so we request a PR bond on his case. I've spoken to the state about that. And if we need to, we can get an agreed order over today. What else? He understands the charge against him, pleads not guilty, and requests to be set on the pretrial docket.
You said that you have seen the indictment.
I have seen a copy of the indictment. My client has not, but I have discussed what he was charged with, the range of punishment for that.
Let's make sure this name is spelled correctly, give him an opportunity to view it.
He said that his name is spelled correctly.
All right, court finds that Mr. Glasgow has waived the formal requirements of arraignment, understands what he's charged with and the range of punishment. He is represented by counsel. Or entering his plea of not guilty into the record, sets this matter for pre-trial hearing on February 1st at 1:30. If there is an agreement on bail, or if there's an agreement that Mr. Glasgow was not timely indicted pursuant to Article 17-151, then the court will make some kind of motion in or agreed order confirming his entitlement to release based on failure to timely indict.
Judge, I will submit that by end of day or first thing tomorrow.
Yes, sir.
Your Honor, do we have the interpreter?
We do not.
You're not, okay.
We have Mr. Trainer.
Judge, I have one more reset, Mr. Audie Yarbrough.
All right. Audie Yarbrough, CR 23-195.
Judge, I would request an additional pretrial on Mr. Yarbrough's case. I need to go over some additional discovery with him, as well as we're still waiting on an offer from the state.
All right. Any objection from state?
No objection, Your Honor.
Sorry, Your Honor. Could you have that repeated real quick? I apologize.
Yes, Mr. Manning said that you had made a motion to dismiss the case and apologize to Mr. Yarbrough. Is that right? No, he said that he was requesting an additional pretrial setting for Mr. Yarbrough. He still has some things to go over with him. And I think he said he was still trying to speak with you all about an offer.
No objection, Your Honor.
All right. Then the court will set Mr. Yarbrough for an additional pretrial on February 1st at 1:30. All right, Mr. Davis. Step on up and let me see if I can find, I'm sorry, Mr. Butler. Bring Mr. Trainer in.
Hello, Your Honor.
Good afternoon, Mr. Trainer. This is in cause number CR 22-62, State versus Corey James Butler. Mr. Butler has been returned to the Benton County custody, but he's informed my staff that he's represented by a different attorney. So I was looking for clarification.
Yes, Your Honor, that's what I was told as well. I have not received any communications from them to my knowledge, but I missed the email for the Zoom on this one. So I do apologize about that, Your Honor.
Did you file a motion to substitute counsel, or motion to withdraw? Did they? There's no motions to sub. There's no motions to withdraw. So right now you're the only attorney of record for Mr. Butler. So
all right.
And I understand Mr. Butler's telling me he hired Mr. Millslagle. So I need you and Mr. Millslagle to get together and do what you need to do to put the court in position to contact the correct attorney, give them notice so that Mr. Butler can begin negotiating with the state.
Okay, I appreciate it, Your Honor. Yes, I'll go ahead and hop right on that.
Okay, so I'm not going to set this for very long. I'm going to set this again for January 4th and ask that you and Mr. Millslagle do those things.
Wonderful. And can you spell his name for me? Can I borrow that pen real quick? Can you spell his name?
Millslagle, I believe it's Millslagle. Does that sound right, Mr. Butler?
Yes, sir, that's correct.
And his first name is Matt.
Right. All right. I will make sure I get a hold of him, Your Honor.
All right, so I'm going to reset this, Mr. Butler. for January 4th. That's my very next setting. So I want to make sure that we get you in here. So January 4th, I'm just going to put status on attorney.
And can you tell me what time, Your Honor, so that I can pass that along to Ms. Cycle?
Yes, it'll be January 4th at 1:30.
1:30. Thank you very much. May I be excused, Your Honor?
Hang on just a second. Let me make
Oh,
sure.
no
Let
problem.
me make sure Ms. Tabraham's not getting more information from Mr. Butler.
Okay, he said he got 37 months on his federal his federal charge. And he was told that these cases would be dismissed once he pled in federal.
I'll let his attorney talk with the state about that. Obviously, we're not part of that, so.
Okay.
Hold on that information, Mr. Butler. Let's get Mr. Millsagel here on January 4th. And let's let Mr. Millsagel and the state see if they can work out your case, okay?
Sir, thank you.
All right, you're welcome. We'll see you back on the 4th. Thank you, Mr. Trainer. If you'll send
All
that
right.
to Mr. Millsagel, I appreciate it.
Yep. Okay. Take care. Thank you, Your Honor.
Thanks, sir. Have a good day.
Bye-bye.
Still no interpreter for you, Mr. Manning. No interpreter for you. So I guess we'll just stand in recess for a few more minutes and give our interpreter time to appear.
Yes, sir.
Mr. Manning, before we go forward, will you need the interpreter to go over the paperwork with?
No, Judge.
No, okay.
I previously, I came out earlier this week and went over all the with all my clients.
Okay, excellent. Okay, all right, then let's stand in recess and we'll wait. And as soon as the interpreter comes on, I'll turn the camera back on and bring them in.
Thank you, Judge.
You're welcome.
That works for,
We're on English here.
Or are you accessing the interpreting channels?
Yes, ma'am.
I don't see them on my end. Are we conducting this simultaneously?
No, ma'am.
No, good. Thank you. The interpreter is ready.
Now,
Hmm.
Maria, we've been having some internet connection issues this afternoon, so hopefully we'll stay up. Oh, that's just talking to you. We hearing it. I did English. We're gonna do it like we always do, where you speak in English and in Spanish. Mr. Manning? Yes, we can hear you right now. Right, and then when you talk to Mr. Okay, Judge is fixing to get on. Hang on just a second.
Yes.
You got C?
Yes, ma'am. Everything should be set up correctly. Ask him to, he shook his head yes earlier when you were talking to him. You're saying that he can't hear you?
Yes, yes.
Okay, Jonathan, just make sure to tell him to speak up, because she's gonna have to hear him through that same microphone, so if he mutters or something, she's not gonna be able to hear him, okay? All right, this is cause number CR 22-191, State of Texas versus Jaime Mario Bentos. And at this time, I'm going to swear in the translator, Ms. De Villiers. If you'll raise your right hand and state your name and license number. Ma'am, do you solemnly swear that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Thank you. All right, Mr. Manning, it's my understanding that Mr. Mario wants to enter into a plea today. Is that correct?
That is correct, Judge.
And before I go on asking any more questions, I want to make sure I understand the agreement. Mr. Mario being indicted with a third-degree felony offense of possession of controlled substance, between 1 gram and 4 grams. The plea agreement is that he would plead guilty to that crime. The recommendation from the state is to be convicted and sentenced to 3 years in prison, $180 restitution, $290 in court costs, $85 in reimbursement fees. State would be dismissing a few other cases that are not indicted and or not filed, a possession of marijuana less than 2 ounces, and another possession of controlled substance, penalty for 2. And Mr. Murillo would be receiving credit time for the time that he's already spent in jail in the amount of 242 days. Is that correct, Mr. Manning?
Yes,
Is that your understanding too, Mr. Murillo?
yes, it is.
Okay, all right, Mr. Murillo, is your name Jaime Mario Bentos?
Yes, it is.
All right. Sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, yes.
Thank you, sir. You can lower your hand. All right, sir. Are you a United States citizen?
No.
Do you understand that if you plead guilty today and the court assesses the sentence provided in your plea agreement, it could affect your status within this country?
Sí.
You understand that you could be deported, you could be denied re-entry into this country, or any other thing under the immigration law that could prevent you from returning to the United States. You do understand that is a risk in this case.
Yes, yes.
In understanding that, you still wish to go forward.
Sí.
And Mr. Murillo, in this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you as your attorney?
Sí.
Do you feel like you have understood everything in your case and everything in your plea agreement today?
Sí.
Is there anything you do not understand or have a question about?
No, todo bien.
Okay. Mr. Manning, do you believe your client to be competent?
I do.
And you've explained to him his rights they pertain to this case?
Judge, I have explained his rights as they pertain to this case, as well as I've given him an explanation of the case law under Padilla and its progeny regarding his immigration status, as well as his application as I currently see it being played out.
And you believe he understands all of those, the inherent risk regarding that, and that he's engaging into this plea agreement intentionally, knowingly, and voluntarily?
I do.
And throughout your representation, have you used the assistance of an interpreter to ensure that Mr. Murillo is understanding and that there's no language barrier regarding your representation in this proceeding?
Judge, I have used multiple sources to discuss Mr. Mario Bentos's case, including interpreter, as well as using language translation devices to make sure that he understands both written and spoken word.
All right, thank you, Mr. Manning. All right, Mr. Murillo, the state has filed an information in your case.
Judge,
Is that correct? Is it an information or an indictment?
no, Judge, it was an indictment. I've gotten the corrected copy of the judgment. It is filed by indictment, and the judgment we have is correct.
All right, so just let me check since mine was wrong. Indictment, POCS, PG 114.
That is correct, Judge.
All right, sir, you are indicted with a third-degree felony offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams. That is a third-degree felony that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and also carries a possible fine up to $10,000. I find that the plea agreement we've already discussed does legally fall within a range of punishment. So understanding the range of punishment, understanding the plea agreement, and understanding the consequences regarding your status within this country. Mr. Mario Bentos, how do you plead to possession of a controlled substance in penalty group 1 between 1 gram and 4 grams? Sir, are you pleading guilty to committing this crime because in fact you are guilty of committing this crime?
Sí.
Has anybody threatened, forced, or pressured you to plead guilty?
No.
Okay, the court does accept the defendant's plea of guilt at this time. Mr. Manning, is there any objection to the stipulation of evidence?
No objection, states 1.
Stipulation of evidence is admitted as State's Exhibit 1. The court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Nothing from defense, rest and close.
All right, Mr. Manning, can you assist the court by reciting the stipulation of evidence?
Yes, Judge. Mr. Mario Bentos was pulled over by DPS trooper who conducted a standardized field sobriety test to determine whether or not whether my client was intoxicated. Upon finding that my client was not intoxicated, he asked for consent to search the vehicle, and upon searching the vehicle, he found drugs that were 2.09 grams of methamphetamines.
Thank you, Mr. Manning. All right, then based on the evidence presented to the court finds that there is enough evidence to convict the defendant of this offense. The court does follow the plea agreement today. The court convicts Jaime Mario Bentos of possession of controlled substance penalty group 1, a third-degree felony, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay a $180 in restitution, $290 in court costs, $85 in reimbursement fees. The court dismisses DA case numbers 2021-673, a possession of marijuana less than 2 ounces, and DA 2021-672, possession of controlled substance, penalty group 2 less than 1 gram. Further, the court awards Mr. Aurelio Bentos 242 days credit towards the sentence for the time that he has already spent in jail on this cause. Sir, you hereby remanded to the custody of the Bantay County Sheriff so he can carry out the terms and conditions of the sentence. Please step, unless you have any questions, please step over with the deputy to be. Thank you, sir. All right, Maria, I think that concludes my need for your services today. Yes, ma'am. Thank you. I appreciate your help as always. Good to see you. Hey, I'm just glad it was you this time and not me. So we're even. All right. Thank you. Merry Christmas. We'll see you next year. All right, gentlemen, is there anything else that you see on the docket that you think I've missed? I think that concludes our jail docket. Ms. Tabram, is there any traditions or any other issues at the jail we can take up?
No, Your Honor.
All right, that will conclude the afternoon criminal docket. The court's going to be adjourned and stand in recess until next year.
Thank you, sir.
Please don't.
Thank you very much, Your Honor.
You're welcome. You have a good day.
You too.